Good morning. The Senate Judiciary Committee will come to order. And today on our agenda, we have time allotted to work bills previously heard. And we are going to then start our business today before the committee with working House Bill 2114 and House Bill 2114. The short title is renaming the Joint Committee on Corrections and Juvenile Justice Oversight in honor of Representative J. Russell Russ Jennings and requiring the committee to monitor the implementation of juvenile justice reforms. Committee, we heard that bill Thursday last week, and are there any amendments or a requirement to have a bill brief from the reviser? If not, then what is the will of the committee? I saw Senator Baumgartner's hand first, so I'll go over here. Senator Baumgartner.
Yes, Madam Chair, I am going to jump in because 2 years ago, I was vice chair of the Joint Committee. And because of Representative Jennings' illness, he contacted me 2 weeks in advance and asked me to chair. And it was during those Oversight Committee meetings that, in fact, the last day, Representative Jennings died. So this past interim session, when I was chair, that was something that we discussed and we did pass out as a recommendation. So I do move that we pass out House Bill 2114 favorably for passage.
Second.
Thank you. And we have a second from Senator Olson. Any discussion on the motion? Senator Wilborn.
Thank you, Madam Chair. And I might add, I served with Senator Jennings, also chairing that committee a few years back, and found him to be very capable, very knowledgeable, maybe one of the better in the United States in that regard. So I sure can support this.
Senator Gossett, did you have a comment? Make a motion. There we go. A second for the motion then. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, let's next take a look at House Bill 2121, and that is, it's actually a substitute for House Bill 2121 from the House, extending the suspension of statutory speedy trial time limitations and providing that time during the COVID-19 public health emergency shall not be assessed against the state. We heard this last Thursday as well. Are there any amendments or motions regarding the bill or discussion? Senator Steffen.
The reviser refreshed my memory on how far out this pushes the end of the lack of speed.
Yes, thank you. The reviser, please.
Thank you, Madam Chairwoman. Jason Thompson, Office of Reviser of Statutes. It pushes the extension until March 1st of 2024.
Senator Baumgartner.
Thank you, Madam Chair. The extension takes us to what they, as a group, had agreed to. So I will move we pass out House substitute for House Bill 2121 favorably for passage.
Thank you. And a second from Senator Olson. Committee, any discussion on the motion? Seeing none, seeing some. Senator Haley.
Brief commentary. Thank you, Madam Chair. I was part of the initial extension for the speedy trial, and certainly I'm sorry to see that we have not gotten this together yet, that we still have a need to extend further, because sometimes rights are foregone because they're waiting for their day in court and not able to get it. But it's only through the representation of both sides, the proponents, the very learned district's attorneys that appeared and that brought written testimony in support of this, as well as those who defend. We heard from bids that we just don't have counsel in place to meet the backlog, that we don't have prosecutors or defense, that I reluctantly do support the motion to extend it one more time, to suspend those rights that others should be otherwise heir to. Thank you.
Thank you. It is good to see that the prosecuting community as well as the defense community has come together to craft what they believe is a solution to. We want to see our judiciary functioning at full capacity as well, and want to make sure that is happening, and that the March 1st, 2024 deadline would give the legislature the opportunity and the requirement to take up the deadline again if it is going to be extended another time. We will be in session next February to take a look at this. And if no action is taken, then statutory speedy trial is fully reinstated. Was there a question? Another question? Okay, seeing none, then you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. Would you like your no recorded? Senator Stephan is a no vote. Thank you, committee. We do seem to have a group of youth in the committee meeting room. Is there someone who might want to speak on behalf of the group and introduce yourselves? If you want to come to the podium real quickly, we'd be glad to welcome you to committee. You'll need to turn on the microphone. There you go.
Awesome. Thank you so much. We're with Team Pact Leadership Schools, which is a ministry that teaches young people about the political process. And so we're here in the Capitol this week teaching them, and we're just really happy to be here.
Well, thank you for being here at the Capitol and welcome to committee. Thank you all. Hope you enjoy your day here at the Capitol. Committee, we are next then going to look at a couple of bills. Just want to check with the revisor on procedure for just a moment. Committee, we do have a motion to reconsider that Senator Baumgartner would like to speak to. So, Senator Baumgartner.
Thank you, Madam Chair. I make a motion that we reconsider House Bill 2350. We addressed that yesterday in committee, but the balloon amendment version that we had was not the most updated one. Even though we were certain it was not. So I do make a motion to reconsider.
Committee, do we need a bill brief from the revisor regarding House Bill 2350? If we could, just a brief bill about that. That is the bill regarding human smuggling, creating the crime of human smuggling and providing penalties therefore. But Mr. Revisor.
Thank you, Madam Chairwoman. Jason Thompson again. Yes, this is the bill about human smuggling. You adopted an amendment. Unfortunately, I did not have the most recent version of that made available to you. So if you vote to reconsider your action, you'd be back on the bill and you could adopt the correct amendment if you choose, and you could pass the bill back out with the correct language.
Is there a second to the motion to reconsider the bill? Senator Stephan, thank you. Committee, any discussion on the motion? Seeing none, then the motion is to reconsider the bill. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We will now then turn to working House Bill 2350. Senator Baumgartner.
Thank you, Madam Chair. I do have at least, our revisor has the latest version. It is the updated version, and I'm happy to explain it.
Yes, Mr. Revisor.
I guess he's happy to explain it.
Oh, I'm sorry. Did you want to, Senator? Or,
It doesn't matter.
okay, whoever wants to. Senator?
Okay. If you look at the first balloon, what's different from what was approved yesterday is the last 6 words. Excuse me, the last 6 words, where it says in exchange for anything of value, that has been added. The other thing that has been added is in the second balloon, number 2, a law enforcement officer or agency shall not consider a person's race, color, or national origin when enforcing this section. So that is what is different. The only thing that is different from the amendments that were approved yesterday. And I would move this amendment, Madam Chair.
Thank you. Committee, is there a second or discussion? Senator Steffen with the second. Thank you. Any discussion? Senator Haley.
Thank you, Madam Chair. And I still, I appreciate the clarification that's been brought, and I think I was opposed to the amendment, not so much for the content or the substance of it, but in fact, some of the terminology that I believe then and believe now has not been affirmed either at the federal level or here versus individual, alien, that kind of quote unquote, those terminologies. I appreciate the cleanup intent that is being brought, though, by the amendment today. My continuing opposition, though, is for clarity to the language that's there and not to the overall bill itself, even if amended. Thank you.
Thank you. Further discussion on the motion? Seeing none, would you like to move your amendment?
Yes, Madam Chair, I move my amendment.
Committee, you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. Would anyone like their no vote recorded? Committee, we are back on the bill. Senator Baumgartner.
Thank you, Madam Chair. I move we pass out House Bill number 2350 as amended favorably for passage.
Thank you. And a second from Senator Olson. Committee, any discussion? Seeing none, then you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries.
Thank you very much, Madam Chair.
Thank you for bringing that to our attention, Senator. Appreciate it. The needed cleanup and the correction. Thank you. Committee, we are next going to take a look at House Bill 2010. House Bill 2010 updates a statutory cross-reference to provide proper jury instruction in cases when a defendant lacks the required mental state to commit a crime. We heard this bill last Wednesday, March 15th, and just a brief bill brief from the reviser, please.
Thank you, Madam Chairwoman. Jason Thompson here again. This is the bill that comes to you with a simple correction to a cross-reference regarding what to do with persons found not guilty by reason of mental disease or defect. It corrects that cross-reference in 3 different statutes. 1 that we identified in the drafting, and then 2 that were added later by the House committee that we identified after it was introduced.
Thank you. And committee, I intend that we, in 2010, that we also add the contents of House Bill 2069. House Bill 2069 was brought to committee by Scott Schultz of the Kansas Sentencing Commission. And House Bill 2069 provides that the service of post-release supervision period shall not toll except as otherwise provided by law. And if we need a bill brief from the reviser, if we could have just a few words about that. There's another bill.
All right. Thank you, Madam Chairwoman. And yes, just to clarify for anybody else that didn't catch that, you're working House Bill 2010, and you're now asking about House Bill 2069 as something to be added to 2010. 2069 is a Sentencing Commission proposal, and it does provide that the term of post-release will not toll when someone is in jail, except as provided in one particular statute. It's kind of a very technical sentencing issue that the Attorney General's office and Department of Corrections identified, and this is the proposed fix for that issue.
Thank you. And these are both criminal procedure bills that kind of fit together nicely. So I would move that we add the contents of House Bill 2069 into House Bill 2010. Is there a second? Second, I heard over here. Senator Haley. Committee, you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. Committee, I propose that we also take a look at House Bill 2070. 2070 is another bill brought to us by Scott Schultz from the Kansas Sentencing Commission, and it allows certain non-drug offenders to participate in a certified drug abuse treatment program. And I would propose that we amend House Bill 2010 by adding the contents of House Bill 2070 into it. Is there a second? Senator Haley. Any discussion? Senator Haley.
Thank you, Madam Chair. It should be noted that both of these measures passed, both the previous one, 2069 and 2070, passed the House unanimously, 123 anyway to nothing.
Thank you for mentioning that. Appreciate that. Committee, any other discussion? Seeing none, Senator Steffen. Did you need a bill brief on 2070?
Well, I had a question about 2010 and the group home situation. And basically, it looks like we're forcing that on any township, city, or county to accept this situation without any input on their part. Is that a fair assumption?
Which bill? 2010 is the question. Well, before we get back on the bill, do you have any questions on the amendment about House Bill 2070?
My apologies for jumping the gun there.
That's okay.
I'll hold tight.
Okay, thank you. We do have a motion, and we have had a second on House Bill 2070 amending into House Bill 2010. Committee, any further discussion on the amendment? Seeing none, then you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. And with that, then, Senator Steffen's question about House Bill 2020 as amended.
Is it 2010 as amended?
I'm sorry, it is. It's 2010. So thank you.
Very good. Thank you. Again, I'm concerned with the way we're so enthusiastically forcing this group home definition on all aspects of our government. As I stated earlier, am I missing anything in the bill from a reviser standpoint, or does it really just take away all local input?
Go ahead.
Thank you, Madam Chairwoman. Jason Thompson again. So I am not familiar with this statute other than for the purposes it's in this bill. I can tell you it was enacted in 1988. It was last amended in 2018. And the only reason it's in here is because on page 2 in line 17, we have to put in the correct reference to KSA 21-5209 instead of the reference in line 16 to the old outdated reference of 22-3220. So that's the only reason it's in here. There's no change to the substance of this law except to make a cross-reference update. It is about group homes and their location. And one of the reasons you're not eligible to be placed in one of these homes is if you've been declared um, under the criminal code not guilty by reason of mental disease or defect. You're then precluded from staying in one of these homes. So that's why the reference is there and why it's updated. But the provisions prohibiting municipalities from zoning or doing things related to the homes, that's current law. And I don't have any background on it. I just know it's current law.
Okay, so on page 1, line 14, I'm sorry, may I respond? Page 1, line 14, what was that? I scribbled over the letter. But anyway, where it brings up group homes, it's in bold, but you're telling me that's old verbiage.
Yes,
Madam
go
Chair,
ahead.
Jason Thompson again. Yes, and unfortunately, this is one of those circumstances where the fonts are required by statute to be a certain bold or italic or whatever. And in this case, because the statute was added by the House committee, it appears in bold, but the changes to it are just in italics. So there's no change anywhere on page 1 except in line 33 and 34 and 35 or 36, right? So where we're just moving the references around, that's not actually a substantive change. And then the change of substance that I was focused on is on page 2, lines 16 and 17. All that other bold language is current law. And the same would go for the other statute that was added by the House committee, section 3, back in pages 6, 7, 8. All of that bold language is current law. The only changes are strike and italics. It's very confusing, and we go through this every year with the fonts, and I should have known that's where we were going. Yeah.
Well, you did a fine job of explaining it, and I'm grateful. Thank you.
Thank you. What is the significance on page 2 at lines 16 and 17, changing the reference from chapter 22 to chapter 21? I'm just curious.
Okay. Madam Chair, Jason Thompson again. So the reason for the bill is that in section 2, what was the original section in the bill, there's a reference to a KSA that's been repealed. KSA 22-3220 was repealed in the recodification in 2011. So this has been an ongoing issue for years, and for whatever reason, it's not been identified or brought to our attention, or a legislator hasn't volunteered to put their name on it and fix it, any number of reasons. When we searched for that number that was repealed, it also revealed these other couple of statutes that reference the same number. So right now, that language in section 1, KSA 12-736 C2 says a person is not eligible for placement in a group home if they've been found to have a mental disease or defect excluding criminal responsibility pursuant to a statute that doesn't exist, right? So in theory, it would operate, right? You have the language you need to operate it, but it cites a repealed statute, and it should cite 215209 to make it legally accurate and enforceable the way it should be. And the same goes for the other two sections. That's the effect of it. It's citing a dead law, essentially. It needs to cite the current law.
It's truly cleanup then. Appreciate that. Any other discussion on the bill as amended? I'm not seeing any. Committee, we're going to suspend our work for a few minutes on House Bill 2010 as amended, and we're going to turn our attention to working Senate Bill 193. Senate Bill 193 was a bill that we heard February 15th, and we passed it out of committee favorably for passage on February 20th. And it has been referred back to committee yesterday to have the committee consider a proposed amendment. And with that, then, I believe Senator Wilborn has the proposed amendment for the consideration of the committee.
Thank you, Madam Chair.
And before we get to that, just a moment, we'll probably need a bill brief from the reviser, because the bill is enacting the Reduce Armed Violence Act to increase the criminal penalties for certain violations of criminal possession of a weapon by a convicted felon that involve firearms. And with that, a bill brief from the reviser.
Thank you again, Madam Chairwoman. Jason Thompson, Revisor's Office. So yes, this was a hearing you had a long time ago. It is a bill from last year, a reintroduction of the Reduced Armed Violence Act. It amends the sentencing grid. It adds a new special sentencing rule at the end of that statute that provides when a person is a, let me get the actual language for you here. It's kind of important that I say it accurately. When a person is convicted of criminal possession of a weapon by a convicted felon, their sentence will be presumptive imprisonment and shall be served consecutively to any other term of imprisonment that they're given, if the trier of fact makes an additional finding beyond a reasonable doubt that the person, that the weapon the offender possessed during the violation was a firearm, and that the firearm was possessed by the offender during the commission of a violent felony. And then the bill defines violent felony to be a list of crimes that are specifically enumerated. I think that should hopefully help.
Thank you, committee. This was a bill that was introduced last session. We did hear the bill last session, and it was favorably passed out of committee last session as well, and died on the calendar. This session, I was approached by our law enforcement community, Association of Sheriffs and Peace Officers and Chiefs of Police, and asked to reintroduce the bill in Judiciary Committee. So did that. And now it is referred back to committee, having passed favorably out, for us to, again, consider a proposed amendment. Senator Wilborn.
Thank you, Madam Chair. I have a proposed amendment. And I might add, before I ask the reviser to explain the amendment, that this is a joint agreement with the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association, and the Attorney General Kobach. And with that, I would like to ask the advisor for an explanation.
Mr. Thompson.
Thank you again, Madam Chairwoman. Jason Thompson. The amendment deals with the new special sentencing rule, again, near the end of the bill. So I didn't duplicate the whole bill, just the last couple of pages here. The first change is in page 10, line 17, to strike possessed and used. You may recall this conversation from other special sentencing rule discussions we've had this year. Used is a term that comes up in the criminal code. It has a different meaning from possessed. And that's the preference here, is to have firearm was used by the offender rather than possessed by the offender. And then there's a new provision in line 22 that's added that says this subsection will not apply to an offender who's prohibited from possessing a weapon under the criminal possession of a weapon statute as a result of a juvenile adjudication. So that statute prohibits you from possessing a weapon if you have certain convictions or juvenile adjudications. So this special sentencing rule would only apply if you're an offender prohibited from possessing a weapon because of a conviction, not because of a juvenile adjudication. That's what that provision would do. The list is maintained. It is moved down to a paragraph 4. That's the little thing there. But the violent felony list remains. And then there are a number of additions and deletions to the list. You'll see that in line 32, kidnapping is narrowed only to subsection A1 of that crime, not any other subsections. Aggravated kidnapping is specified in subsection B of that section. Similarly, in aggravated assault, it's limited to B1, not the other sections. And aggravated assault of a law enforcement officer, it's limited to D1 and not any other provisions of that statute. So I won't go through each of those, but those boxes are narrowing the crime that is a violent felony to only specific subsections of that crime. So only very specific conduct, not the whole crime, like it might have been before. You'll note on page 11 that in line 2, robbery and aggravated robbery are removed from the list. In line 8, aggravated endangering a child is removed. And in line 14, burglary is removed. And finally, in line 17, arson is removed. So that's what all that strike is. Those provisions are removed. Those would not be violent felonies for the purpose of this special sentencing rule. And then the last thing I would mention is in line 12 and 13, This is the felony drug offenses. It's small, but I wanted to note it because I know it's been discussed heavily both in the House and the Senate. The change from 5703 or 5705 and removing 5706, that would remove possession. So this would only cover manufacturing and possession with intent to distribute. 5706, possession is stricken by this amendment.
Thank you. Do we know, you've mentioned, Senator, a question for the carrier of the amendment, that law enforcement is supportive of this. Do we know the district attorneys and county attorneys' position on it?
To answer, I cannot answer that
Okay, thank you.
without fact.
And so page 11 is the list of violent felonies that would be struck from the automatic increased sentencing penalty were you to be a convicted felon who then, as the bill is introduced, possesses a firearm in committing these crimes on page 11. Is that right, Mr. Revisor?
Madam Chair, this list is right. So there's two parts. You're first a convicted person who's prohibited from possessing a weapon, and then you commit one of these violent offenses, and that triggers the special sentencing rule.
Thank you. Committee questions about the amendment. Senator Haley.
Thank you, Madam Chair, and thank Mr. Thompson for helping to clarify some of this. And I'm looking through the list, primarily page 11 that he went through, and I'm trying to appreciate the rationale in the striking of what appears to me certainly to be more egregious acts by those who might be carrying a firearm that have been struck. I'm not going to list those again. We have them in front of us, certainly burglary and robbery, etc., that have been struck and will not be a part of this amendment if adopted. But then the maintenance of, certainly from my mind, line 23, the fleeing or attempting to elude a police officer, which we have undertaken in another measure, I believe Senate Bill 174, that would again call for this enhancement, one which I think this that the legislature is still debating, so that it might be another bite at the apple at what I believe is something that is potentially overly or overkill, if you will, for the addition. So I'm concerned, Madam Chair, by this amendment because we're taking out, or it does not include, I guess, some concerns for violent activities, and then but we're keeping in or putting in one that is not necessarily so. Again, for me, it's the fleeing or attempting to elude a police officer, which is not an inherently dangerous crime. So I just wanted to mention that I support the intent that's being offered by this amendment. I just don't understand the dichotomy as to why they would be listed as such.
Would the carrier of the amendment like to respond?
I appreciate the senator's sentiment, and he always gives thoughtful remarks to this. All I know, I wasn't part of the discussion with the law enforcement group that I just mentioned before, and with the Attorney General, and this is the agreement that they came to.
Do we know, as part of the discussion, to kind of follow up the question that was just asked, what about the crimes on page 11 that are being struck from the list make them different than the crimes that are being kept in the list? Do we have any insight into that? I don't know if you
do not, other than that was the final agreement.
Yep, thank you. Committee, other questions or discussion? Seeing none, then I think we need a second for the motion still. So Senator Baumgardner with the second then. Any discussion on the motion? Senator Baumgardner.
Thank you, Madam Chair. I would just like to add that I know that last year there was quite a bit of discussion on line 17 of page 10. And there was concern expressed last year that the original language said such firearm was possessed by the offender during the commission of the violent felony. And there was concern because, well, how would they know that they were in possession and so forth? So I think it's appropriate that it is amended to say such firearm was used. And I think that that is significant change and addresses the concern that we went round and round with last year.
Question for the reviser. The bill would only apply to convicted felons and not anyone else, correct? Convicted felons who then, if the amendment is adopted, use a firearm when they've been prohibited as a convicted felon from possessing a firearm, but they use it in the commission of whatever is still on the list on page 10 and 11. Is that right?
Madam Chairwoman, yes, and I'll point you back to the exact language, lines 9 and 10, very end of line 9. The sentence for a violation of criminal possession of a weapon by a convicted felon as defined in that statute. So that's number one, that this is your sentence for that crime. You've committed that crime. And then, that's the sentence that we're dealing with. And 2, the weapon you possessed was a firearm. And 3, the firearm was used during the commission of a violent felony. So all of those things have to be met to use this rule. So you're dealing with a violation of criminal possession. And on top of that, you have a violent felony committed as part of that.
Thank you. If there's no further discussion on the motion, then you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. Would you like your no recorded? Senator Haley would like his no vote recorded. Thank you. Committee, I will make a motion going back to working House Bill 2010 that we amend the contents of House Bill 2010 by adding in the contents of Senate Bill 193 as amended. Is there a question or a second? Senator Haley.
Madam Chair, before we move forward, I do have an amendment that I'd like to offer to Senate Bill 193.
I'm sorry. Sure, Senator, is your amendment written and the reviser could pass it out?
It is.
Thank you.
Thank you. 183. And Madam Chair, no, I don't. Thank you.
Senator, would you like to explain your amendment or have the reviser?
I can be brief, and if Mr. Thompson could augment that, I would. We've had the discussion briefly before, Madam Chair. This basically, and I'll say it in lay terms, this would be an enhancement for sentencing for the criminal discharge of a firearm into where the peanut is, where into a motor vehicle or into a dwelling where there's a human being, regardless of whether the person discharging the firearm knows or has reason to know that there's a human being present. In other words, this speaks to random discharge into a house or to a car of a firearm, just and not aimed at someone, I guess, just randomly shot into it. And that would be a sentence enhancement that would run, is it consecutively or concurrently? The additional months, but not a concurrent. Okay, the additional. So what is the additional month? Matt, it is concurrent. So essentially it's a sentence enhancement for those that shoot into houses or cars without really aiming, and where there is someone that they knew or should have known that there was a human being present.
Thank you, Senator. If Mr. Thompson wants to add anything, I have questions about how it plays. I guess it's on page 12 of Senate Bill 183, but if the reviser could maybe take that up. I'm thinking Senate Bill 183 had the sentencing grid in it and therefore was a lot longer than what the amendment is.
Correct. Thank you, Madam Chair. Jason Thompson again. And yes, as Senator Haley mentioned, this is his bill. And rather than mark up a balloon amendment, I just provided the bill, not knowing which one it would go on, this being the candidate. So yes, the bill itself, you'll see jumps. The balloon I handed out, or the amendment, it's just pages 1, 2, 3, and 12, right? So I didn't copy the middle pages, but they would be included. Essentially, this would add the contents of Senate Bill 183 to Senate Bill 193, as Senator Haley said. The first section is the crime of criminal discharge of a firearm. It really doesn't change anything about that crime other than separate out the provisions so that it's clear when there's a person present. And the reason for that is so that it can then trigger a special sentencing rule. So I'm not really changing the substance of the law of criminal discharge, which is the same crime that you're enhancing in the underlying bill, right? This is the crime, or not? No, this isn't the same crime. It's near that crime. It's not the same crime. I apologize. So you'd be enhancing this crime, and to do that, I change it so that we can reference a specific subsection. So the real peanut of the bill, as the senator was saying, is on page 12. This would add a special sentencing rule, just like the other bill would. But this special sentencing rule would apply to violations of criminal discharge if the trier of fact makes a finding beyond a reasonable doubt that the offender discharged a firearm and that the offender knew or reasonably should have known that a person was in the dwelling, building, structure, or motor vehicle. So that references back to the prior sections. And that gets you an extra 60 months, 5 years. And then the other one is if the person was less than 14 years of age that was present in that dwelling, et cetera. It's an additional 120 months or 10 years. The sentence imposed is consecutive, and I missed that at first. So that was the back and forth we were having off mic there. This would be consecutive to any other term that's imposed. So you would have your sentence for criminal discharge and whatever else, plus a consecutive 60 months if you violate the first one, plus an additional 10 years or 120 months if you violate the one where the person under 14 was in the place that you shot at. I hope that clears things up.
Thank you. Committee, is there discussion or questions? Senator Wilborn.
Thank you, Madam Chair. I understand the intent of the contents of 183. However, it does break the agreement, and I don't know what it would do to the contents of 193. That is not what is agreed upon, and that particular area was specifically struck. So I'll probably oppose the amendment.
Further discussion? Seeing none.
Well,
Senator Haley.
thank you. I appreciate the observation of the senator, but I think that this dovetails, frankly, to my reading with what the underlying intent of 193 is. I mean, we're talking about reducing armed violence is the title in the bill. It's to reduce armed violence and increase criminal penalties for possessions of weapons. Well, it says by convicted felons, and this amendment doesn't say by a convicted felon, but there's nothing more, I think, there's nothing more armed violence than someone who is willy-nilly driving around shooting into houses and shooting into cars, where people are. That's about as bizarre as it gets, and it's a problem in our society. We have people driving around shooting into houses and shooting into cars. We have innocent people, sometimes children, who are struck by these projectiles, by these bullets, by these people who are violent criminals. So I think it augments the bill. I don't know why this bill is rushed through as it is, and I'm prepared to reluctantly support it, despite the fact that it brings in other things that are not violent, like fleeing or attempting to elude a police officer. But adding this brings teeth to genuine concerns for the reduction in armed criminal violence. And I would hope that we would do something meaningful and add this to the measure, Madam Chair.
Thank you, Senator. Senator Gossage.
Yes, Madam Chair, I'm wondering on then page 11, lines 8 and 9, why we strike aggravated endangering a child. That could happen, right, if in a drive-by? It was just mentioned a child could be hit. Am I missing something?
So you're looking at the proposed amendment for Senate Bill 193 and comparing what that does versus what the proposed amendment part of Senate Bill 183 is looking at. And the question was, why does the proposed amendment that got onto the bill that strikes, which part did you say? Aggravated endangering a child?
9, I'm just curious.
Line 8 and 9, which the amendment that amended Senate Bill 193 struck from the list of crimes that a convicted felon would not have an sentence enhancement if the person were to be convicted of aggravated endangering a child, why that was struck, and how that plays into putting this in. That would be a question probably for the reviser.
Who's holding both hands to his head?
And I would let the reviser answer, Mr. Thompson.
Madam Chairwoman, Jason Thompson again. I don't know that policy wise, they might have some relation to each other, but we're talking about two different sentencing enhancements for two different crimes. So on the one hand, you've got a felon in possession of a firearm who then commits a violent felony, and we have an enhancement for the felon in possession crime. So you also have the sentence for whatever violent felony you committed, right? So let's just say you committed aggravated endangering a child and you were a felon in possession. Well, you wouldn't get the special rule, but you would have committed two crimes and you would be sentenced for both of them, and the judge could do whatever with the sentence. But let's just say you're a felon in possession who commits criminal discharge of a firearm, right? Right now, you would get this enhancement that you've amended, or if you adopted it and it became law, right? You would get the enhancement of consecutive sentencing because you committed felon in possession of a firearm and you committed criminal discharge. With the added amendment, you would get two enhancements. Because you committed the violent felony of criminal discharge, it would trigger the one penalty and it would trigger this new penalty as well. So they could interact and they could both be used in that very specific case.
Thank you very much. Thank you, Madam Chair.
The aggravated endangering a child that was struck by the amendment is defined as recklessly causing or permitting a child under the age of 18 years to be placed in a situation in which the child's life, body, or health is endangered. So, and then we have the proposed amendment. So, further discussion. Senator Wilborn.
Thank you, Madam Chair. I hope I was clear on my remarks. I was mostly concerned about breaking the agreement. Quite candidly, I like the inclusion of this particular crime in this bill.
Committee, is there further discussion on the amendment? Seeing none, I think I was just going to say we need a second on the amendment. Is there a second? Senator Steffen. Any further discussion on the motion? You all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill, which is Senate Bill 193 as amended. If there are no other amendments for Senate Bill 193, I would like to go back to working House Bill 2010 and move that we amend House Bill 2010 by adding the contents of Senate Bill 193 as amended. Is there a second? Senator Baumgartner. Committee, any discussion? Seeing none, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Thank you, committee, for your work on House Bill 2010. Before we entertain a motion to pass House Bill 2010 as amended, let's have a brief from the reviser about the contents of House Bill 2010. Mr. Thompson?
All right. Thank you, Madam Chairwoman. I know for my purposes and the folks here at the staff table, this is really helpful. So hopefully it is to you too. I appreciate the opportunity to recap where we are. So House Bill 2010 would now contain the contents of House Bill 2010. It would also add the contents of House Bill 2069 related to tolling of post-release supervision. It would add the contents of House Bill 2070 about non-drug offenders participating in the Senate Bill 123 program. It would also add the contents of Senate Bill 193 as amended, which includes the contents of what used to be Senate Bill 183. And that would be everything that you included.
Committee, any questions for the revisor? Seeing none, then I will move that the committee pass House Bill 2010 as amended favorably out of committee for passage. Is there a second? With the suggestion of a Senate substitute, and Mr. Thompson, you have a recommendation on that as far as how it's going to be presented to the Senate as a whole and proceed from there if it does?
So, Madam Chairwoman, the two things you would see different. Number one, it would become Senate Judiciary's bill rather than Representative Heiberger's bill. So that sponsor would change if that's of relevance to anyone. And then the font would change. So rather than seeing all of your new pieces in bold with italic and strike changes, just like sections 1 and 3 of underlying 2010, it would all look like section 2 of the bill. It would be plain font with strike and italic add. So it might be a little easier to follow, but you do lose.
I think is a cleaner bill, considering some of the conversations we had about fonts earlier in a bill. Maybe just a clean bill would be helpful for the legislature as the bill advances, if it does. So with that, then I will withdraw my motion and change it to have a Senate substitute for House Bill 2010 as amended, pass favorably to the Senate as a whole for passage. And we've got a couple of seconds over there with Senator Baumgartner and Senator Olson. So Senator Baumgartner with the second then. Thank you. Committee, you all have heard the motion on the Senate substitute for House Bill 2010. Do I need to say amended? Senate substitute for House Bill 2010 move favorably for passage. All those in favor signify by saying aye. Those opposed, no. The motion carries. Thank you, committee. We'll stand at ease just a moment. We're trying to determine, there's a couple of bills that have amendments not quite ready to work today. So just wanted to check in that that was still the status. Just a moment, please. Let's stand at ease. Committee, we are waiting on some proposed amendments for a couple of bills that are not quite ready. We are running out of time. So if we're going to work those this session, let's please get those amendments ready if possible. And with that, then, committee, thank you for your attention today and your work on these matters. Thank you for those in the committee meeting room and following along online, and to our staff. With that, then, we are adjourned.